Hi, my name's Adele Schofield. I'm a Solicitor and Director at Berkson Family Law Solicitors. In this video, I'm hopefully going to explain and clarify for you the potential overlap between child arrangements orders and child protection, and what if other family members want to make applications and what orders are there to support them if they want to care for children. So just to expand and talk a little bit around those areas for you. In the short answer, it is yes. Other family members, if they have anxieties or worries about how a parent is caring for a child and there hasn't been any referrals to social services, maybe they know that, say, a parent is drinking, they may be holding it together enough to not raise the concerns of other agencies, but you as a grandmother or an aunt that sees the family regularly know that this isn't how your niece or grandchild or nephew is being raised, then yes, you can make an application to court for a child arrangements order, live with. However, as a relative and not a parent and not someone who has parental responsibility, you have to first of all ask the court's permission to make that application. And what the court look at in giving you that permission is what sort of order is it you're asking for. Will it be a child arrangements order? If the court allow you to make that application, is the child going to be harmed in some way by that application being made? The final one is your connection to the child. How close a relationship have you got to the child? It's normally going to be quite a close relationship, either a grandparent or an aunt or something of that nature. There is also another private law order that you can apply for, which is a Special Guardianship Order, which is a lot more assessment involved in that, and you would need to involve the local authority in seeking that assessment moving forward. But I think the easier application to make, if you've got very instant concerns about your child or your grandchild or a niece or a nephew, is to make an application for a child arrangements order, first of all seeking leave. Kinship care is a phrase that is often used about a relative or a close friend of the family caring for children. So it's a phrase that is used, it's often used in public law cases, but you can also have that in a private law case. And it's basically a close family member who is caring for a child who isn't a parent. And that's what kinship care in effect means in the United Kingdom. Special Guardianship Order does give you enhanced parental responsibility. Once you've been assessed and if you are given a Special Guardianship Order, it means that the parents still have parental responsibility, and you should still tell them about which schools you want to put a child in, or any particular operations, or why you're going down a certain medical treatment route for a child. But if, say, the parents disagreed with you and the decisions you were making about the child for those important decisions, they can tell you that, but you as a special guardian can use your parental responsibility exclusively and say, well, I don't agree that you've got it right, I think I'm making the best decision, and therefore this is the school that I'm going to be putting the child in. So you can use the parental responsibility in an enhanced way over and above that of the parents. You don't all share it equally. Whereas if you had a child arrangements order, live with, you would all have the same level of parental responsibility. And if there was a disagreement about a school and you couldn't resolve it, you may have to make an application to court for something known as a specific issue order to say that the child should go to a certain school. So there are advantages to being a special guardianship order because of the enhanced PR. As I say, it depends on the nature of the order that's being applied with. If it was a child arrangements order, live with, it may just be a CAFCAS officer who sees you as wanting to be the person that cares for the child on a live with order, and the parents, and they speak to the child and they prepare what is known as a welfare analysis as to what is in the child's best interests, and make final recommendations as to who a child should live with or how much time they should spend with their parents if you were a grandparent seeking to care. So it is an assessment. They would want to know that you have appropriate accommodation and what you were going to do about schooling and on those basic things. But it's not as involved as a special guardianship assessment. That is an assessment that the local authority have to undertake. It is often quite a lengthy assessment. It can be far more intrusive. They will go into far more detail about your own history as being parented yourself, your relationship histories. They will want references from maybe previous partners, from people who know you, who think you'd be a good special guardian for the child that you're being assessed for. They will also want what are known as enhanced police checks, which are called DBS checks, and they will also want medical information. They will probably also discuss finances. So it's actually, it can be a far more intrusive assessment, but if you think about it, it has to be, because the court need to be satisfied that if you become a special guardian, you're going to have that child's welfare and you're able to exercise that enhanced parental responsibility in a safe and appropriate way over and above that of the parents. So there is good reason why it is a more involved assessment, but it just is more involved. Whenever you make an application to court for a child arrangements order, the court is what is known as seized of the arrangements for those children. The court may have had evidence from the initial CAFCAS safeguarding letter, the information that's been filed in parents' statements, or a CAFCAS officer who's done more inquiries, and it may be that that information begins to cause such concern for the judge that's reading those papers that he thinks, I'm worried that this child should maybe be made subject to what are known as public law orders, either a care order or a supervision order. And in those circumstances, what the court will do is they make a specific direction. It's called a Section 37 direction, which is a direction to the local authority in which the child lives to prepare a report as to whether they think the child needs to be safeguarded by either a care order or a supervision order. If the child doesn't need to be safeguarded that way, the court want to know, well, what supports can be put in place to make the child's circumstances better. So the court itself does have those powers of protection. And if in certain circumstances the information the court have is so worrying when they see it and when they read it, the court can actually make of its own motion an interim care order alongside that direction to safeguard the child immediately. But often it's just a report that's required to look at the child's circumstances. It goes back to the paramountcy principle. The child's welfare is the court's main concern, their paramount concern, using that list of factors, which is a child's age, wishes, thoughts and feelings in light of their age and understanding, their emotional, educational and physical needs, any effects a change in their circumstances might have on them, their age, sex, background and any other specific information that may be relevant to the decisions you make about a child. For example, has the child got any special learning needs or disabilities, any risk of harm that the child may have been at when being cared for by one or both parents, and then the ability of the parents and or anybody else who's been looked at to care for the child, and finally the range of powers that the court have, what orders should be made for the child. Is it right to make an order for this child? So that is all the information that the court feed into the decision-making process for the child and the family. If, say, you have a live with order and there is a spend time with order with another parent, and you know that that parent has a relative who, for various reasons, has a difficult background, maybe they've got convictions for violence, quite serious violence, or even sex offences, and you think that is someone I do not want my child to be in contact with at all, or if it is, there has to be supervision, really close supervision around it, because it's just not safe without that. In those circumstances, it may be possible for the parent who has the live with order to say, I also want another order, which is known as a prohibited steps order, to prevent the parent who spends time with bringing the child into contact with the person who is highlighted as a risk. As I say, it's not often that would happen, but sometimes there are those cases where you need to be sure that your child is safe if they're spending time with a parent. They are schools and GPs and in particular, and health visitors are normally the ones who make the referrals for families to social services in the first instance. It may be that children have gone into school and made allegations about what they've seen at home, if it's violence, or school have seen a parent attend to pick a child up from school under the influence of drink or drugs. So they may then make a referral to social services. A health visitor may attend at the property and see the state of the home just isn't appropriate, or the child's not in a particularly hygienic state, and they may say, I need to make a referral to social services. And GPs as well, if a parent goes in to see a GP and they present with a child maybe with injuries or with in a really poor state of neglect or something of that nature, they may then decide that they need to make a referral to social services. So they are really the front line in terms of safeguarding children on a day-to-day basis, and the ones that normally make the referrals to social services, unless, say, it's been a police call out over an incident of domestic abuse at a property as well. Yes, a parent will have parental responsibility still. It's only in extremely rare circumstances would parental responsibility be removed, and it would normally be from the father, unfortunately, where there's serious convictions of murder and or rape or something of that nature, which would mean they shouldn't have PR to be exercising for their child. But in all other cases, yes, if you're not caring for a child, you should still know about their school, you should still know about their health and the treatment that they're getting. So that is always something you should be communicated to you by a carer, and you should also be able to have a relationship with the child. Normally, if it's somebody else caring for the child, there's been risks at home, so they would need to know that that relationship is safe. So it may be that your contact is supervised by professionals or family members. But yes, you would usually, and the expectation is that the child would still know and have a relationship with you if they're being cared for by extended family members, whether it's under a child arrangements order or a special guardianship order. Yes, the child's wishes and feelings are relevant. It is one of the factors that the court need to consider. It is dependent on their age, but even children from as young as 3, guardians normally undertake direct work. They draw pictures, they ask them questions about houses and islands and who they like spending time with. So the children's voice is always heard, particularly if a CAFCAS officer has been appointed and had to do a report. There is always a piece in that report about the meeting with the child, the work they've undertaken with the child, what the child thinks about each parent and the time they spend with them. So their voice is heard. How much weight is attached to that voice ultimately in the decision-making process depends on the age of the child. In certain circumstances as well, the court in very complex child arrangements cases can appoint the child or make the child themselves a party to the proceedings, and in doing that the child has a solicitor, and a CAFCAS officer would become their guardian and make recommendations on what they think is in the child's interests ultimately over and above everything else that's going on for the child. And the solicitor would also, depending on the age of that child, see the child and communicate the child's wishes and feelings as well. So there are and always is an expectation the child's wishes and feelings will be known in some way before the hearing and the court. Hopefully I've given a little bit of an explanation about child arrangements order and how there is an overlap with child protection and what you can do as a concerned relative if you've got family members who you feel that you need to intervene in that. So hopefully I've explained the processes there for you. Here at Berkson Family Law Solicitors, we have a number of solicitors who are experts in children law. We are able to offer a listening and empathetic ear to you and your circumstances and talk you through every step of the proceedings and the work that needs to be done to support your application before the court, and explaining what can be difficult and emotional time for you. And as I say, sometimes legal aid is available for that if you have the relevant evidence of domestic abuse and are on a low income, and in particular, say, a passported benefit like universal credit.